Yes, Mr. Green.
Thank you, my Lord. Just before I move to ground 3, you may or may not have had an opportunity to look at Chakrabarti.
We have.
The short adjournment, and I'm sure then the court will have identified paragraph 114 as the relevant passage.
Yes, so it was 113 and 114. Yep.
Yes. 113 is what the implied terms are, and 114 is where Mrs. Justice Singh, she then was, says that fairness is a subset of the implied term of trust and confidence, but it isn't freestanding or discrete. And then, my Lord, I also took the court to the observations of Lord Justice Coulson in the case of Gregg, but there are just a few other passages that I should just draw the court's attention to. In the authority, it's paragraphs 114 to 116, so page-wise, starts at 493, is when the court is analysing whether the judge...
So, sorry, you got to the head of me. What, sorry?
Page 493, my Lord.
Yes.
I've taken it to 111, which is the... 111 talks about should the judge have granted the injunction, and then at 114, dealing with whether the judge had applied the right test when concluding that the trust was in breach of the implied term. And the court says that equating the implied term of trust and confidence with a more generalised obligation to act fairly is wrong, and says that, and then sort of says that's not the law. Moreover, that the judge had said that the trust had to exercise its discretion lawfully and reasonably. As Mr. Sutton pointed out, that too was incorrect. The touchstone is rationality. And then over the page at 115, the court says that that's not simply a technical point or linguistic quibble, refers to Mahmood and refers to Gogay. It's a severe test which is required to demonstrate any breach of the implied term of trust and confidence. And then for good measure, at 116, there'd been a failure to consider whether the confidence was calculated to destroy or seriously damage the relationship and whether there was reasonable and proper cause for that. So that is the law as it stands in relation to fairness. And of course, as the court knows, this is not before this court as an implied term case, because we were refused permission on the implied term argument. It was said that it was clause 1.16 or nothing by Lord Justice Dean. But I would simply say this, and referring back to HC 99, is it really to be said that the collective parties have dismantled that and replaced it with the implied term, which is almost of necessity imprecise, and where there is a severe test that has to be applied in order to demonstrate any breach? That would seem to be a remarkable proposition for the
I think we need to look quite carefully at what the actual issue was in Gregg, where I see, interestingly, the judge appealed from was the judge in our case.
My Lord, yes.
Actually, then wasn't.
Actually, then.
So, by the way, for the rest of today, I do not permit the use of the phrase as he or she then was. We all know when judges be promoted.
Of course.
Yeah.
But anyway, that is it. I mean, of course, I mean the topic. I take your point, my Lord, was somewhat different in Gregg. It was all about whether or not, from recollection, whether you should await criminal proceedings before pursuing disciplinary proceedings.
Yeah, I mean, it may well purely procedural fairness may be slightly different from what you might call substantive fairness.
Yes, but it is all bound up with the implied term of trust and confidence, and the observations, the observations in Gogay about the severe test certainly hold good across the piece. That then brings me to ground 3, which is an alternative only to ground 2, because if the court is with me about relating to, then the test is not one of relevance. But if the court is against us on that, then the question, it becomes one of who decides. Is it a question which the court decides whether the documents were relevant or not, or does the court decide only whether the case investigator's exercise of her discretion was rational, in the sense of the Braganza sense of taking into account all relevant considerations and excluding all irrelevant considerations. And I took the court before the short adjournment to the analysis by the judge at paragraph 100, where she opts for the latter, and the court already has my submissions as to why I say that reasoning is unsustainable. But perhaps most importantly, if one looks at paragraph 1.16, 1.16 is all about rights. It's a package of rights afforded to the doctor, of which a constituent element is that the doctor must be given an opportunity to see any correspondence relating to the case. It is not a clause which confers a discretion on the trust to make a determination of whether to provide the documents or not. It requires them to provide the documents, which for present purposes we'll say are the documents relevant to the case. Although dealing with a different subject matter, the court has in the authorities bundle the case of Matu, and the case of Matu starts at page 121, but it is a case concerned with who decides. In that case, it was who decided whether the allegations against Dr. Matu were allegations of personal or professional misconduct, because if professional misconduct, that called for different procedural protections to be adopted by virtue of MHPS. Simply for the court's note, at page 125 are the relevant clauses. And that's
125 in the bundle.
125 in your authorities bundle, my lord, and it's paragraph 4 of Matu. And the key provision was clause 3.2 is that it's where the alleged misconduct relates to matters of professional, or the investigation identifies issues of professional conduct, then you need to get independent professional advice. But, and this is the key part, where a case involving issues of professional conduct proceeds to a hearing, then you have to have an external member. So It was rather important whether it was one or the other. And then just for completeness, there is clause at 4.5, which says that you can get mixed conduct and capability cases, and there the trust decides on the most appropriate way forward. And then turning forward to page 145 is the analysis of Lord Justice Elias. And he says that he identifies what the question is and what the implications are of that under clause 3.2, and does not accept the submission of Mr. Kavanagh that a term in the contract which provides that it is for the trust to decide upon the most appropriate way forward makes the trust the final arbiter of which procedure should be adopted, subject at least to bad faith or the absence of reasonable grounds. So he says the court decides, and it's not an exercise of looking at bad faith, it's not an exercise of rationality, the court decides. And we say, as in Matu, so here, the clause 1.16 doesn't confer a discretion on the trust. It doesn't call for the trust to make a discretionary decision of any kind. It requires the trust to provide correspondence relating to the case, and arguing against myself for the purposes of ground 3, that means relevant, then there is not the very clear language that's referred to in Matu that excludes the role of the court in that full sense, which requires the court to make its own determination of whether the documents sought are relevant or not. And I will, if I may, in relation to ground 4, come to why we say if the judge had applied her mind to that question, which she didn't, then she could only have decided that in favour of the appellant. Because ground 4 is again an alternative, it's an alternative to ground 3, because by ground 3 we say, well, it is a matter for the court to decide whether the documents are relevant or not. But if we're wrong about that, then we say that the court got it wrong in its approach to the assessment that it carried out of the case investigator's exercise of discretion. And perhaps the fundamental difficulty in this case is that the respondent put no evidence at all before the court to explain why the case investigator had determined that some of the documents were not relevant. All that the court had is what is recorded at page 88, forgive me, of the core bundle, and where the court deals with the question of breach at paragraph 105 and 106. And she notes correctly at 105 that the claimant hadn't seen the documents, the court hadn't seen the documents, but said that there was other evidence on which the court could form an assessment of the decision. And refers to the date of appointment of the case investigator and the 22 interviews that she conducted. She was well placed, says the court, to assess relevance, better placed than the court. But there was literally no evidence before the court adduced by the respondent as to why the case investigator had formed that view. It was literally a case of, I say that these documents are not relevant. So there was absolutely no material on which the court could work. It was a bold assertion that the documents were not relevant. And of course, the court didn't have the disputed documents at all. The appellant at the case management phase had asked for standard disclosure, and it was objected to strenuously by the respondent, who said that the documents ought not to be disclosed and therefore ought not to be before the court. And in my submission, any requirement placed on the claimant to show a prima facie case that the documents were potentially relevant has to be seen against what might be thought rather an invidious backdrop where you literally do not know why the case investigator says the documents are not relevant. And you can't see...
Well, I see all that, but you're not really addressing the judge's reasoning, which was that you have a threshold to meet. She relies on what's said in the case of, in fact, she doesn't spell it correctly or indeed give a proper reference for it, but I found it, well, it's in the bundle now anyway. It's Dalgleish, which she says is authority for the proposition that, I paraphrase, that it is for the claimant to show some reason to believe that it may be relevant.
Yes, I accept that, my lord, and that is indeed what Dalgleish says. But the point being that has to be nuanced in a case where the claimant effectively has nothing to work on because the respondent holds all the cards and has kept all the information from her. But if one looks at what is recorded at paragraph 106, and just factually this is incorrect, but I don't think anything turns on it. The judge says that during a cross-examination it emerged that the claimant had concerns about the decision taken to commission the Campbell investigation, which reported in November 19, whether or not correspondence in March 19 with the parents led to the decision to commission the Campbell investigation is not, however, of relevance to the terms of reference. In any event, suspicion is not sufficient. Well, to deal with that in turn, I mean, first of all, it was in fact in the claimant's witness statement that she had concerns about the fairness of the process. And of course, concerns about the fairness of the process is precisely the sort of thing that you might want to
What do you mean by the fairness of the process? That's a very vague phrase. What process?
Well, what I mean by that is, factually what had happened in this case was concerns that the patient had very unfortunately died. There'd been a root cause analysis. It appeared that there was no criticism of any of the individuals involved. There was then a meeting and some correspondence with the parents, and then things change.
Yes, well, okay, but I still don't understand the point. Suppose it was something that the parents said that encouraged them to commission the Campbell report.
Yes.
And it was the Campbell report which then did make criticisms that were not made in the root cause analysis.
Yes.
How would that be relevant to the job which the case investigator had to do?
Because, my lord, it might be said that it was not fair to open up the question again and to
But that, the
commission
case investigator has no power to decline to do what they've been asked to do on the basis there's some sort of abusive process or issue estoppel.
And I'm not suggesting for a moment, my lord, that would be a basis for the case investigator not to do her job, but it would be relevant, or might be relevant, for the case investigator, for the doctor to be able to say, well, hang on a minute, everybody was happy about this, and then there was the correspondence with the parents, and there is something in the correspondence with the parents which calls into question whether or not matters were dealt with fairly. For instance, whether there was an attempt at that point to pin the blame on the claimant, to make the claimant the scapegoat for what had happened, and that certain representations had been made and statements had been made on the basis of those assertions that had been made. That's the sort of thing that bears on the question of whether the trust has behaved fairly towards the doctor, and is something that she might well want to say something about in the investigation, because an investigation, and I know I've made this point before, isn't just about who did what to who and when and how on the 3rd and the 4th of December, but looks at, or certainly the doctor can ask the investigator to look at other things, ask the investigator to look at fairness and mitigation and so on.
But how is the fairness of the investigation, relevant to whether or not the serious concern is made out in substance? Surely that's the real issue.
Well, my lady, for example, it might be said that the concerns that have been raised are overblown because there's been an attempt to pin the blame on the doctor. And actually, if you take a step back and actually look at the matter critically, then actually the fault isn't that of the doctor, or it isn't the fault of the doctor any more than anybody else. Or it might be a basis for the doctor to suggest a different resolution of matters that the case manager
But those suggestions can be made regardless of whether or not the trust has changed its mind or adopted a different approach at different stages. I mean, but those points can always be made.
But the difficulty that faces the doctor is she does not know what, and on the face of it, it's something of a stark change. There's an RCA. There are no criticisms, no major criticisms of anybody.
I've understood the anxiety, but my question is, well, whether or not there's the anxiety isn't the question. Whether in substance there is a serious concern.
But my lady, I would say that does raise an issue as to the potential relevance of these documents.
I see. All right.
And then there is, and effectively there is nothing to counterbalance that then from the trust. There's no explanation as to why the documents are said not to be relevant.
Well, that's fine if you get to the first stage, but the question is whether the premise of your argument, whether there's any need to explain.
I accept, my lord, that of course one needs to look at both phases. But if you're with me on phase 1, then I do say that phase 2 poses difficulty, and perhaps at risk of stating the obvious. If it was so obvious that this correspondence was not relevant, why was it provided to the case investigator? It must have been thought that the correspondence was at least
You've made many
potentially
good
relevant.
points, Miss Riddle. That is not your best point.
Yeah. But in any event, the position originally was that it was thought that the appellant already had it. And effectively, for those reasons, we also say, well, that Mrs. Justice Thornton ought to have said the documents are relevant. If I'm right on ground 3, that the documents are relevant and you get them in any event. Just one final point that I should make on the question of relevance as well is this, and I made this submission below, was that documents may be relevant because they themselves can lead the case investigator to form, consciously or unconsciously, a critical view of a doctor that don't go directly to the allegations, but they may well want to say something about in terms of being able to provide their view of events, which also, brings into question issues of fairness and issues of culpability or degree of culpability. My Lord, I'm mindful of the time. It's just past 2:20. I could, at this juncture of the court, would like me to deal with the respondent's notice, or it may say that you'd prefer me to deal with the respondent's notice by way of reply. I'm entirely in the court's hands.
Well, there might be something to be said for that. Unless my lord and my lady disagree, which they don't. Thank you, that's a sensible suggestion.
Thank you very much.
Yes, Mr.
I'm grateful, my lord. What I'd like to do is start with a summary of what the issues and the concerns of the respondents were in relation to the appellant. In other words, look at some of the documents that brings us up to a point where we have concerns that are put into an NHS process.
Well, you must do what you think necessary, but there's some quite precise legal points here.
Yes.
And there's a good deal of what I might call colour stuff in your skeleton already. I'm not sure we need much more of it.
But, my lord, I agree. I'm not going to make a factual speech to you and the bench about what this case is about to bring in any emotion. What I'd like to do, given that the inquiry is about essentially whether the claimant is entitled or the appellant is entitled to the document as a matter of law, you've got to look at the facts. You've got to look at the underlying material.
Well, let's not spend time about it. You will notice my note of caution that I
absolutely
introduced that.
Yes, my lord. Can we just start really with what I say are the stark facts in relation to this case, because the facts inform the investigation and the NHS process. So, just start. You've seen the TORs, that's in the respondent's bundle at page 202. They are short and precise. In other words, whether the decisions taken by the appellant in this case were appropriate and reasonable. Now, your Lordship has already, Lord Justice Underhill has already observed that they appear to be slightly vague.
I don't remember saying something like that. They are certainly
not
very
as specific as one would expect.
Okay.
That's my language saying that slightly vague. The point being that what happens in this case is that the claimant is the consultant on call. Miss Marnay, to use the proper pronunciation, is her specialist registrar. And what happens is that the patient A, very poorly individual, the patient A is subject to 2 operations conducted unsupervised by the registrar. That's on the 3rd of December and the 4th of December. And during this, the claimant does not attend in order to see the child.
We've picked all this up.
My lord, absolutely.
Mr. Gordon, I'm sorry to interrupt you. And of course, if my lord and my lady want to hear more about this, then we must. But although the facts of this particular case have given rise to this appeal, the issues of law which are raised by the grounds of appeal, as far as I can see, are general. And they turn, for example, ground 1 turns on the construction of a clause, which is going to apply to every other practitioner in the country. So how are we being assisted by knowing the full facts of this particular case on that question of construction?
But my lord, I'm not going to give you the full facts. What has been absent in my learned friend's submissions and in her skeleton argument, and indeed in the resistance to have any of the documents that we wanted in for the purposes of the appeal, is an absence of the materials that the claimant had for the purposes of what she would have known the interview was about. And I set that out in my skeleton argument. If you don't want any more of it, I'm happy to leave it there. It's all in my skeleton argument.
Well, I think what would help me, and it sounds to help my lord, is if you address the points of law. If on the points of law it then becomes necessary to say or to illustrate by reference to particular points about the facts of this case,
yes,
so be it. But a general introduction is not focused from our point of view.
my lord, so be it. Then I'll be a lot quicker than, I hope, than an hour than I anticipated I would be. Can I deal with ground one then, which is the, we say, the obligation that the claimant claims, the appellant seeks in this court, to have a general right of disclosure based on the correspondence relating to the case clause. And my lord, what we say in relation to that, which the judge accepted, is that that can't be right for a whole series of reasons, some of which are testing the sense of it, in other words, stress testing it to see whether it makes sense or not, with the industrial reality, absurdity, and so on and so forth. And also by reference to what in fact happens later on in the process, depending on which stage you go down. So if we start from the proposition that correspondence must mean that, in other words, an exchange sent from one party to another. Now, my Lord Justice Underhill picked up this morning, specifically looking at the clause in question. This is 1.16. Can I take the court to that page 203? It has 6 obligations, but they appear to be paired.
It appears to be what, sorry?
Paired, put together. There are 2s.
Oh, I see.
First is in writing from the case manager that an investigation is underway, and the second is the name of the as well as the name of the case investigator, and then the knowledge or being made aware of the specific allegations or concerns that have been raised. So that really is at the very outset of the process. The next set.
So what's the pair? So that's a pair.
Yes. So the case manager says there's an investigation, and here's the case investigator, and you should know of what the or be made aware of what the.
It's a bit over analytical. I thought if you're really being analytical, there's 3 obligations there, but I get the point.
But
That's basically telling you the absolute basics.
Yes, you're being told an MHS process has commenced. But who is the case manager, who's the investigator, and what it's about, what the allegations are. The next set of obligations is that you must be given the opportunity to see any correspondence related to the case, together with a list of the people that the case investigator will interview. So we say that, again, is a preliminary step. That is matters of, as your lordship said this morning, of high level. And this feeds into our respondent's notice, which is that we say that that really is a matter in respect of stakeholders, people who may be interested or be involved in this from the beginning. And the simple example is NCAS. So if I can take the court briefly just to cross-reference this, if the court goes to page 201, paragraph 1.9.
Hang on 1 second. So the basic submission is that what's been referred to as correspondence relating to the case is correspondence with stakeholders.
Yes.
About the disciplinary investigation.
About what is going on. I'm going to
cross-reference. Okay, that's rather vague.
Well, I'll take your lordship to the examples that we gave as appear in either in the defence or in the judgment.
Helpful. Yes, okay, keep going.
So what we say is, if you go back, if I can take the court to paragraph 1.9 onwards.
Sorry, I'm still behind you. Where are we in the
page
bundle?
201, core bundle.
Yes.
What you are looking at there is, as it were, the first stage, the first of the 3 pairings. So you're looking there with the problem, the concern. So,
sorry, where are we?
Let's start a little bit earlier.
Which paragraph are we in?
At 1.6, but then we go to 1.9. But you do need to see all these clauses in order to.
No, I just wanted to know where you were. 1.6, yeah.
1.6. So that deals with the initial part, how the case manager is appointed, how a designated board member is appointed also. That's the friendly ear, so to speak, on the board of somebody who will oversee exclusion and any representations that might be made by the excluded doctor. Then we go over the page over 1.6 the medical director will need to work with the director of human resources, OD, and NCAS to decide the appropriate course of
What
action.
does OD stand for?
Usually occupational something development.
I think it's usually organisational.
Organisational development.
What does that mean?
Organisational development.
What does that mean?
It's a hybrid, or it's related to human resources.
I'll put equals HR.
Yeah. Although if you're an OD specialist, you may not be happy with that.
If I'm really old, I'd say equals personnel, but that is
But
very
we
old-fashioned.
definitely don't say that.
Or if I was very up with it, I'd say people. Yeah, okay.
And then NCAS. And here is one of the stakeholders who we see being repeated throughout this process. Because what happens is, it comes about in slightly more focus and detail under 1.9, which is where I was going to take you to initially. So the case manager is in place, and MHPS process is commenced. You have at 1.8, just to jump about it, 1.8 there's an issue in relation to potential danger, GMC, GDC. So you have that there. Then at 9, what then happens is the case manager has to go about the serious business of what he or she is going to do. And 1.9, 1.10, 1.11 onwards talks about the interaction between the organisation and NCAS. What NCAS do, and I'm not sure...
So hang on, we all know this is a badly drafted document. When it says in 1.6, the medical director is responsible for appointing a case investigator, that's premature, isn't it? I mean, you don't appoint a case investigator straight away. You only do that once you have decided to have an investigation, which is further down.
Yes.
Yeah, okay. So
This is our lift. In other words, my client's lift of MHPS.
yeah, it's not a criticism of your clients. It's a criticism of MHPS. But I won't be the first person to have made such criticisms. Right.
So you've got the stage right coming in if there's a potential serious danger to patients, GMC, GDC, 1.8. So there's another potential stakeholder. In other words, somebody who might be contacted to deal with immediate fitness to practice issues. Then you've got 1.9 identifying if there is a problem. So you've got 1.9 and 1.10 dealing with...
I'm sorry to be a nuisance about this. If this is strictly sequential, at 1.7 and 1.8 you will have already decided that there's a problem. Otherwise, why are you troubling the GMC?
Well, it's not necessarily going to go in the direction of an MHPS process and the case investigator being appointed and so on, because if we go down at 1.11, which Milena Friend took you to this morning, you can have root cause analyses which might be premised on or related to a serious clinical event, but it might in fact be explained through that process, and therefore it falls out of or doesn't continue in the MHS process. So it's quite flexible in terms of what eyes are in terms of looking at it.
Could there be more than one stakeholder, to use your phrase, who has to be informed?
My lord, there are.
So in other words, it's not necessarily a sequential process. There might be things happening in parallel. Is that right?
No, absolutely, my lord. No, and I raised this before, Judge. If I take you very briefly to page 85 in the core bundle, paragraph 97, just to short circuit this. This is the judge's findings in relation to what it means, but specifically, about third line from bottom. These are the organisations which are likely to be told about the investigation to be receiving and sending correspondence. They include the GMC, NCAS, and then there's a reference to the trust policies, the National Patient Safety Agency, the police, the Director of Public Health, and the Medical Director of NHS. And these are all set out in our defence. We pleaded these points specifically on the issue.
So it's helpful to read the sentence before the sentence you started with. The choice of language in this respect corresponds is consistent with the numerous references, blah, 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 to communications between, blah, blah, blah. So that's the
Milady, yes.
sentence that introduces that.
Yes,
provision.
that's the sentence, and the specific references are those which we've referred to there.
So although she hasn't used your language of stakeholders, that's what you mean by stakeholders.
Yes, and my lord, in fact, just not wanting to go too far into the weeds, stakeholders themselves are identified under the training material. So just this may just help to illuminate the point. If you look at the appellant's unagreed bundle at page 34, you weren't taken to this because this wasn't the point learned friend was making. You see, again, reflective of what we said to the judge are stakeholders and what correspondence relates to, you see under stakeholders at the top may include either internal or closely external matters, such as directors of education, deans, and so on. And then the bottom column, or the bottom box, has a familiar group of individuals or organisations which we just looked at.
So are we looking at the stakeholders box or the others who may be involved in the investigation process box?
We looked at others for the purposes of, just the bottom one, 34, other stakeholders. They are the same, but it's given a more specific...
So what are the same as what?
Well, those who are involved in the investigation process might also be stakeholders as well.
Maybe.
Yeah, they may not be, but they may be. So I just, for illustration purposes, give you that.
Well, this does at least remind us, which I think everyone's made this point, but you do have to keep it in mind, we're not only dealing with cases arising out of clinical incidents.
No.
And there's reference to police and so on. You might get a complaint of sexual harassment of a patient,
Yes.
sexual misconduct, or
colleague.
fraud, or fiddling their expenses, and this procedure has to cover the whole range.
Yes. It has to paint with a very, very broad brush. Going back to 1.1, page 201, the principal stakeholder one sees coming out from that document is NCAS. They are an advisory body who provide advice which is open. It's not subject to legal privilege or anything along those lines, in which the doctor is allowed to see and does see, either directly from NCAS or if they ask their employer, the employer will provide it. And in this case, the claimant was provided with the NCAS letters of advice. So it's all cards on the table, so to speak. They go to NCAS because they're obliged to go to NCAS to get the advice. They say to NCAS, we've got these concerns. This is the basis for our concerns. This is what we're proposing to you to do. What do you say? So we say, therefore, the second pairing, the second group of obligations under 1.16 points decisively to a higher level. It's not dealing with the granular. It's not dealing with correspondence flying about within the course of any investigation, who's seeing where, whom, when, and so on and so forth. It's dealing with that specific...
Yeah, but you've got two... you've got two kinds of documents that you're, in principle, might be concerned to exclude. One, which doesn't actually come up in this case, is documents generated by the investigation itself.
Yes.
Speaking for myself, it's quite easy to see why there shouldn't be a right in the doctor to see those. However, what we're concerned with here is documents generated by prior investigations, or with a small I, prior considerations of the same subject matter. There you haven't got quite the same concerns about interfering with the integrity of the process. If every time the case investigator wrote a memo to themselves, if they had then to disclose it because it was a document relating to the process, one can see the obvious problems about that. But that isn't quite the same with documents of the kind that have been sought here.
Well, my lord, I will address you directly on what the documents are being sought here and how they have arisen and what they have led to.
Fine, do that, but at this stage, I'm just concerned to see whether there's a distinction to be made with the pre-existing, pre-investigation documents, which are obviously, in the broad sense, relevant.
Well,
as a matter of policy,
we say if it arises, if it's correspondence relating to the case, it has to be relating to an MHPS case. It must be.
Precisely.
It must be. That is the only reason why it is in there. That's the connection between the higher level body or the
so by definition, a document generated before the case came into existence, the investigation formally started, cannot be a document relating to the case.
No, it isn't. And it isn't correspondence relating to the case.
Well, that's another matter, but
well,
the 2 points to some extent overlap, but they also to some extent are separate.
But
let's assume correspondence includes other documents. But actually, some of the stuff here is correspondence. It's letters to the parents. So
yes.
So you're hanging your hat on the phrase related to the case only meaning relating to the case once it is in existence.
Yes,
is that right?
Accepted. That's what I put in my respondent's notice, which is that this is a clean kill on any view, which is to say, even if Malone and Friend is right about relevance and everything else in respect of those letters are in March 19. The MHS process has not started until January 20.
Just sorry, coming back to the actual submission, I put it to you sloppily. I said relating to the case once it's in existence. What I really meant was relating to the investigation once it's in. Is that your submission?
Yes, it has to, because, well, the case and investigation are used interchangeably here because it's an MHS investigation, which therefore amounts to an
MHS
case
manager and a case,
and you then investigate it.
Yes, so but this is. Sorry, as you can tell, I'm thinking aloud. It may not be helpful to you, but it's helpful to me. Actually, you have a case manager before you have an investigation.
Yes.
Because one of the first things a case manager does is decide whether or not there should be an investigation. So in fact, it's not. I was right first time round when I put to you relating to the case with a capital C, perhaps is the best way of putting it.
Okay. When there is
so a letter to the NCAS written on January the 1st may, you would accept, be caught by this, even if the investigation starts on February the 1st.
Yes.
Yeah, okay.
Because it's dealing with stakeholders who have an interest in the process, the NHS process.
Yeah, so it's case, as my lord said, it's case with a capital C,
yes.
not the underlying facts of the case.
No, because, and I deal with this in my skeleton argument, if Malone Friend is right, the obligations that will bring in will be not only significant, it will have significant effects and ramifications if she's right about the submission she makes. So this is really going to my respondent's notice as much as it's going to my 1.1.
No, why not? Don't care which order you take it in. This is proving very helpful.
Which is that we say there's a clean, sharp edge to this, which is it has to be correspondence relating to the case being the MHS case. The correspondence that relates to the March 2019, the two sets of letters, fall outside of that immediately. And that should have been the end of that part of the case, with a capital C and with a lowercase c. So that's my...
No, that should be, yes, the lowercase c.
The lowercase c.
Part of the claim.
So that's what I say is the complete route.
Well, that's very... I'm not saying it's right, but we see exactly how you put it.
That's the complete route, the complete answer to dealing with this, save for the argument made in respect of the RCA statements. Because you still need to get past correspondence, meaning documents. And it's only if you get past that do you then get into the issue of the
Now I see that.
the RCA
But, well,
statement.
can I just understand something on the facts here, which I hadn't focused on before, I hadn't needed to. Remind me when the case manager, who I think was Ms. Shaw?
Ms. Greer.
Ms. Greer.
Well, my lord, I've just heard that it was changed because there was Mr. Turnock. There was
The
Ms.
medical
Murdoch.
director is the sort of default original case
That
manager.
is Miss Murdoch, who sends the TORs in the
Okay,
March and
but
has
sorry,
a meeting in the
it's
team.
my fault. We'll put names to them in a minute.
Yes.
When was a case manager first appointed?
The case manager is in the January of 2020. So, Your Lordship,
If we look at that letter, the letter of January the 30th.
so what you have at page 196 is following a meeting.
I'm so sorry, 196.
196 of of the respondents bundle,
Oh,
or bundle, unagreed.
I'm sorry, I've been confusing you. I've been using the numbers at the bottom, 454.
That's the trial bundle. I've been the top right.
I don't mind which, but okay.
Can we go to the top right? Because all my
Yes,
notes
yeah,
are
no, of course,
on the
that's
top
how
right.
your references work. I'll adapt. So, okay, yes, 196. We're looking at the same thing.
So there you are. Just this is the breathing or the living example of what we've been looking at paragraph 1.6 onwards. The claimant is told, or the appellant is told, that there are concerns in relation to clinical decision making and that her practice is being restricted. That's the top paragraph. Mm-hmm. What then happens is that is followed up on the 4th of March.
No, we're going too fast. She's already case manager by this. So this is
Correct.
from Professor Murdoch, and she says,
I'll be the case manager.
she says, between the hole punches,
Yes.
there's an the restriction of duties will be reviewed at the end of the mission report. We've assessed it does need to extend this further. And as case manager,
Yes.
so he doesn't actually say, I am appointing myself case manager.
Well, which she does that.
Yes, no, wait a minute.
As discussed during the meeting,
Yes.
I will be the case manager.
So is this the right way of reading this? At the meeting, of which I don't think we have the minute, or maybe we do, but we don't need it. At the minute, that is, in a sense, when on your analysis, the case with a capital C starts,
Yes.
and as medical director, she is the first case manager.
Yes.
But she, and then this letter really confirms a week later what had happened in that meeting, and
Yes.
therefore refers to herself as case manager. Okay, that's very clear. Let me just write this down. I mean, we may not know, and it doesn't really matter. Presumably, I don't know whether there was any internal process prior to the meeting of the 24th of January to appoint her case manager. I think not, because the way the thing works is by being medical director, she is ipso facto case manager. But anyway, as far as the outside world goes, and more precisely as far as the doctorate goes, she's case manager as from the 24th of
As
January.
the 24th.
Right, okay.
And she's told that for 197, third from final paragraph, as well as if you go one step above, the designated board member. So in other words, the machinery of MHPS is cranking into place.
Yes, I'm sorry. I'm just being very narrow about this question of case manager. She goes on being case manager for a bit, but at some point she's replaced.
Mr. Turnock succeeds her until August.
When do we see that? Where do we see him being?
I'm not sure you've got that level of granular detail.
Okay, I'm not sure we need it, but at some point
you
after.
don't.
Yes.
And then, but can I just? And then Miss Greer takes over in the September/October Of course, this is the year of the pandemic, in which the hospital is rather stretched in terms of resources. So Mr. Turner comes back. He was a former medical director. He comes back on an acting basis, has hold of this for a period of time, and then is succeeded by Miss Greer. Miss Greer is one of the witnesses, the three witnesses who gave evidence to the judge. So, Miss Greer is the name really that you ought to be.
Thank you. I was only interested in this detail to put flesh on the bones of this concept of the case.
The case, absolutely.
Being a formal creature which everyone knows when it starts.
Yes.
And I had at first confused myself by thinking it started with the investigation. It doesn't.
No.
It starts formally with the appointment of a case manager.
Yes.
She does in fact start an investigation, but that's not until March. Is that right?
Well, that's correct. Well, my Lord, we were looking at 197, as it were, the full procedure is being cranked through. Designated board member. She identifies herself as the case manager, and then says, "I'll communicate with you about the scope of the investigation, confirm the name of the case investigator." But there's no doubt that the case had started by that stage, because it has the absolutely clear effect on the claimant that she has her practice restricted. She's told that there's a case started, and she has her practice restricted. And indeed restricted from all clinical duties. That's on page 196, first paragraph. So it's then, the 24th of January, followed up by the 30th of January 20, that there is an NHS case commenced. And then, my Lord, just for the sake of completeness, 202 A, I think it's entitled, has the TORs which we've looked at. And then if you look at the one we're concerned with is bullet point 1. And then
Sorry, you said 202.
It starts 4th of March. It's actually 202A. The A is slightly obliterated. But it doesn't
I
matter.
see.
You've got
202A.
that.
Yes, no, I've got that.
You've got that.
Yes, yes.
TOR 1, first bullet point. Then over the page, there is then set out again the replication of what we see under the case investigator. Dr. Wood, or it should be Miss Wood, is identified as the case investigator. And there, in that letter, you will see, so in relation to the first obligations or pairings in 1.16, you've got the identity of the case manager, you've got the identity of the case investigator, you've got the identity of the concern. Then what you have is on the second pairing, or the second issue, is you've got not, here's all the correspondence related to the case, but here are the people identified so far. So you've got that on page 204.
Is that in compliance with the middle bit of clause 1.16?
Yes, basically saying these are the people we're going to interview.
Yes.
Can we just see, just following that up, so at 201 to 202 is the terms of reference. 203 says what the case investigator's duties will be in fairly general terms, what kind of report they have to produce. Then at 204, just below the first hole punch, as part of the investigation, details regarding the following will form part of the investigatory approach.
Yep.
Correspondence, so it doesn't say you'll get them.
No, what that's a reference to is what I was trying to convey very early on, which is that there was up until this point, there had been a whole series of reports, statements, investigations given by the
That's all pleaded, and we see that in
the and then you've got 2 is the list of those who will be interviewed. So there's your one.
As my lord said, that's the compliance with what you're calling
the second pairing,
the 4th obligation.
Yeah.
Sorry, I know I'm putting one thing that puzzled me in my pre-reading, and we may as well deal with it now as any time. In the agreed facts, at para.
Which page is it, you think?
The agreed facts are in the supplementary.
Yep, I've got them. My apologies. I've got them. They're at page 3. Start at page 2.
With, para. No, I think I must have confused myself. It's become clear since. I was concerned that there was a suggestion that the claimant had received all the RCA statements. We know they hadn't. That's what puzzled me.
Yeah, paragraph 22.
Yeah, and then, but even the 11 she did get, she didn't get straight away. She only got eventually.
She got them on the 3rd of November.
Yeah.
Yeah.
After consents had been received. Okay, I'm sorry.
Yeah.
I was taking you away from your point. I just
my lord,
wanted to clear that
no,
up.
what I was just highlighting the point is done, so we can move on, was that here was the broad spine of MHBS being replicated in actual life to the claimant, telling her what is going to happen. And who, in particular, this is the 4th obligation, who's going to be interviewed. Then if we go back to 1.16, you've then got the final pairing, as I call them, the opportunity to put your view of events to the case manager and given the opportunity to be accompanied. That doesn't arise in this case because of the dispute between the parties, and the claimant has refused to come to an interview unless and until she gets the documents which she says that she is entitled to. And indeed the relief which the claimant sought before Mrs. Justice Thornton, and it's a relief which is replicated in the skeleton argument of the learned friends, is that the whole process should be stopped unless and until these documents are provided, and that's quite an extreme.
Towards 1.16, I thought in that sentence in the middle that one thing is perhaps of some interest is the use of the future tense, will interview. So the only express obligation to disclose anything in relation to other people is, first of all, it's only to be a list of those people.
Yes.
Not, for example, what they say.
Correct.
And secondly, so following on from the same point, temporarily, the use of the future tense makes it clear that at this point, this hasn't yet happened. This is what will happen. But it doesn't say that once we've interviewed them, you will be given their statements, for example. No. It's just simply silent on that. So the only express disclosure that's going to be afforded under that sentence is any correspondence relating to the case, and we've heard your submissions about what that means, together with a list of the people that the investigator will interview.
Well, my lord, and it should be said in this case, more interviewees were identified, and the claimant was told about that. So we accepted, as we have throughout in this process, that we want to help. We want to keep everybody informed.
No, I understand. All I'm asking for your comment on, because it may or may not be right, is that it appears that it's not envisaging, for example, that before you yourself come for an interview, you will be given what all these other people have said. So it's not saying that at all. It's just telling you that before they are interviewed, you will be given a list of who we're going to interview.
Yes, they are.
Which may or may not be of any interest to you, may or may not be of any use to you, but that's all it's saying expressly. You're going to be given.
Yes, it's the most generalist procedural code one can really imagine.
Presumably the thinking behind it is you may want to say, oh, well, I'm quite sure that X or Y was in the theatre, and you've missed that, and they'll be able to give relevant evidence.
Yeah, absolutely. If you know the estate of interviewees, and this is precisely what's happened in this case, the claimant was saying at one stage, and even threatened in her letter of claim, if I remember correctly, that one of the breaches that my clients have committed is that they haven't interviewed more people than they should. Well, she didn't go that far. She certainly thundered it in correspondence well before the letter of claim. So it is an element. There is an element of an iterative process and a cooperative process, and that's what we've done with the claimant. So going back to my Lord Justice Singh's point, absolutely, these are basic building block elements to a procedure. No more sophisticated, no more finesse than that. And that leads me directly onto my points, which I pick up in my skeleton on construction, in relation to what Milena Friend's argument is about correspondence meaning documents and where that would lead, what that would lead to. And I say it would lead to a very surprising set of results and outcomes which can never have been in the contemplation of the authors of this procedure. Can I just go into some of those points which I raise in my skeleton? I'm conscious I'm not going to repeat myself and read them all out. Can I just make some basic submissions as to why this doesn't mean and cannot mean the general obligation of disclosure? Because that's what Milena Friend's argument is. And this is largely, in any event, taken up by the learned judge at paragraph 101 of her judgment. She accepted respectfully our submissions as to why the interpretation sought to be placed on correspondence related to the case was just wrong. Can I just highlight some big fundamental issues as to why, or points why that was wrong?
Keep telling us.
Yeah, I keep teasing you with it. I'll get on with it. First of all, nowhere within the estate of MHPS is there a general disclosure obligation. So nowhere does it say that there is an obligation to provide disclosure. Where it does provide disclosure, it is quite specific and quite limited. In my speaking note, which is in the supplementary bundle at page 131. So these are the submissions I was making. Can I just take the court to that very briefly? We give four examples as to why the argument being raised is entirely inconsistent with other provisions of MHPS, which are in fact dealing with a much more advanced stage in any given process. Because all we're dealing with here is an interview, whether an individual comes to an interview or not. We're not dealing with a case that has been found or established by virtue of the report. A case manager decided there's a case to answer and it goes to a panel. So what I'd like to take the court to very briefly, page 143 of our...
Sorry, I thought you said 131.
Oh, I beg your pardon. No, it's 131. My apologies, it's 131. And I can cross-reference this to MHPS in the bundle. So when you get beyond the interview, when you get a report, and the report it satisfies the case manager, you get to a conduct hearing, yes, at which your job is imperiled potentially. The process to be adopted is very permissive. In other words, what you are obliged to disclose are matters which you are relying on, not a general disclosure obligation to give everything that you have. So it's rather like the CPR in that sense, but you're not obliged to give adverse documents. It's what you are relying on. So at a conduct process, there is a unilateral obligation on the employer to give what they are relying on.
All right, I can't resist, although I suspect we will be pretty reluctant to say anything authoritative about this in our judgments. But since you yourself are relying on it, are you really saying that if a trust was aware of a clearly helpful document on a crucial matter in a conduct allegation, and through, let's leave bad faith out of it, through incompetence and lack of fairness, through incompetence, failed to disclose it while relying on other documents which went the other way, there would be no breach of duty towards the doctor?
I'm not saying that. Of course there would be. Of course there would be. If we had material which entirely contradicted or significantly contradicted our case, and we kept it back, that would be a breach of the implied term of trust and confidence. And that would
in case you're safe in a way, but I suspect your clients might not like it for the future. You're safe in a way to say, and you accept that would be the same as well at the investigatory stage, because no case on the trust and confidence duty is before us. But are you saying the same is so at the investigatory stage?
That's slightly more nuanced in the sense that what could happen is that the case investigator could regard something as not being relevant, but the case manager could regard, because the case manager who makes the decision whether a case proceeds, the case manager could take a different view. If the case manager is deceived about matters, then we start to get into a sort of duty-like sort of scenario if there's a manipulation. But on any view...
duty as in J-H-U-T-I.
Yes,
not
yes.
duty as
Yeah. But there may be a breach by the employer acting through the case investigator. It may not, it depends. But I'm very...
Well, do I understand you to be saying that you, without quite rightly committing yourself about any particular state of affairs, in principle, it could be a breach of duty to withhold relevant documents from the doctor at the interview stage, so that you asked the doctor a whole lot of questions based on documents A, B, and C, knowing that it would be highly relevant to his or her answers if they saw document D.
But, my lord, yeah, if what you're holding back is the ace in the hole, in other words, is something that would completely exculpate the doctor, that extreme case undoubtedly would be a breach, in my view. But there are lots of cases in which things are held back in order to get somebody's view. So, for instance, counterfraud. Evidence of what happened which is observed on CCTV or whatever. Counterfraud is the better one. What doesn't happen in such cases is that you give...
I don't know what counterfraud is.
Well, if somebody's claiming either expenses or allowances or anything along those lines, which the trust thinks they're doing it dishonestly and they're doing it in a way so as to deceive them, what the trust might say is, we want to see you, we want to have you in order to discuss the issue of your allowances. And this is an MHSP investigation. We have reason to believe that you may not have been honest about it. What you don't do in interview is furnish them with all the evidence that you have. So that's an extreme case whereby it may be in your interest not to say anything. And of course, there are so many different permutations because you might actually see the doctor first and not see anybody else. Or it might be that you see the doctor at the end of the process, which is contemplated here. Or it might be that you see them in the middle. It's entirely fluid.
No, I understand.
And it would be perhaps a mistake to set out any principle.
You understand the reason why, speaking for myself, but I think also for my lord and my lady, we're interested in this more general duty, is that it is relevant to the case. Well, the duty must hang on 116 because there's nothing else, and there are circumstances, as you have accepted, where in principle there must be a duty of disclosure. But I think it follows from your answer that you acknowledge there is such a duty. How it plays out in a particular case is a very different matter. But in principle, in order to conduct a fair investigation, you may have to disclose some documents.
You may. It depends.
You may. But that duty doesn't depend on 116, which is all we're concerned about in this case.
Yes, absolutely.
Yeah, okay.
Absolutely. No two cases are the same.
No. I'm not trying to snooker you into some general distraction, which I will then put in a judgment, and the trust will have to be. But we will have
dig my own grave.
Trust will let me stuck with forevermore.
Yeah.
Okay.
Yeah, but I do want to be absolutely clear about this. That there is no obligation under 1.16 to provide the claimant or the interviewee with anything. There is no obligation at all. And in certain cases, that could be entirely right and correct. The fraud instance or example I've given to the court. In this case, is a much more nuanced case because, as you've seen from my skeleton, the claimant has had a whole welter of matters in relation to what she says and other people have said, experts in particular, about what happened on the 3rd and 4th of December in particular. So this is a case at the other end of that spectrum, in that this is a case in which the claimant has had not only the reports and been able to write reports herself on matters, but this is an exceptional case in which the claimant has actually had the questions. Now, that point, I respectfully suggest, needs some emphasis here, but not
Well,
at any length.
Does it?
It is unprecedented.
You keep on trying to show us how fairly the claimant was treated
Yes.
generally, but we're dealing with a point of principle here.
I understand that, but in point of principle, certainly from my client's point of view, it is that not only have they bent over backwards to help the claimant, but they also take the view that the claimant's criticisms made of my client are most unfair. They have done all they can to try and get her the material she wants in order to have this process terminated in whatever way. But Lord,
in a sense, perhaps I can make this observation in case anything comes off it. Again, I say it's in no way critically, but in a sense you've created a problem for yourself by giving as much as you have, because then you have got a distinction between, you've got 14 documents all essentially of the same character, namely the NCA statements, the RCA statements, of which you're withholding 3, at least one of whom seems to be pretty central. The reason you're withholding it is for a completely different reason, which is to do with confidence or absence of consent.
Yes.
That may or may not be a good reason, but that's not for us to decide on this appeal.
No, but also there is the point as well, and the judge finds this, that the material that was procured during the investigation involved those individuals, the 3 who withheld their consent. And so, in fact, the material that the investigator has is far more focused than what the RCA statement actually was. It's an express finding made by the judge. In other words, the RCA process is a generalised process. Well,
nobody knows. Nobody knows what this statement said. Well, you may know, but
well,
the judge didn't, and the claimant doesn't, and we don't. So
no. What this is a finding is relating to is the fact that Miss Wood gave evidence in the clearest terms, and it was accepted by the judge, that the evidence that she procured from those who gave RCA statements, in fact, were more detailed in certain circumstances. So, in other words, they're more refined, they're more specific, and that you get that. You get that at 68. So we looked at that page 78.
I feel guilty. So I've led you down this, I think, ultimately irrelevant.
I must try and resist the temptation to put the facts in as often as I can.
Yeah, well, I'm sorry I even opened the door.
I'm
sorry I opened the door for you to
turn.
do so. Let's get back to the point you were making.
Yes. So the point I'm making was we were obliged to give her nothing, to give the claimant nothing, and we gave her an awful lot. And what I've done in my skeleton argument is point out, and in fact it was pointed out to the court below, is that in certain other spheres, that is entirely consonant with how they operate. So the criminal sphere, for instance, and we put two sets of materials before the judge. One was in relation to the ACPO guidance about pre-interview briefing, and the other was in relation to the Home Office guidance in relation to pre-interview briefing. And that, again, makes the point clearly, we say, which is that even in the criminal environment, you're not entitled to see everything that the investigator has.
Certainly not unused material, or what later on becomes unused material.
You're not allowed to see anything other than to be given a outline basis of the case.
Well, it depends. I'm not sure we need to go there.
No.
It does depend.
It depends for the...
If, for example, somebody has so far proffered an alibi defence, and you have DNA evidence putting them at the scene, before you do the second interview, I think you'd have to tell them, this is what we've now found. Do you have anything to say about it?
Yes. Yeah, I accept that. But on a general basis, even in the sphere of crime, there is no pre-interview.
Certainly.
And likewise in relation to the employment sphere, the ACAS code says nothing at all about providing this. And all that is simply going to the point that the interpretation that the learned friend seeks is one which is outside of any other regulatory environment. That's the first point. The second point is that it would then create an obligation which would be unmanageable. This is my learned friend, so isn't it all terribly hard? Well, she said that on at least 2 occasions. That's not really doing justice to my point. My point is her case is that whatever the case investigator sees, you are obliged to provide. And that is a very onerous responsibility, both in terms of capturing that information and disclosing the information. And I've set this out in my skeleton, paragraph 42 onwards. You are being held to a regime which is in fact not even known under the civil procedure rules and the standard disclosure. The standard disclosure is you disclose that which you rely on and what's adverse to your case or to your opponent's case. So you would be, as it were, if you accepted these submissions, you'd be going down a road which would bring a whole novel way of how these matters are dealt with, creating huge obligations which cannot live with, in fact, the provision that it sits in 1.16. So those are, in my respectful submission, the reasons why the argument on 1.16 are just cannot be.
You also emphasise that the timetable envisaged in these procedures is obviously a speedy one.
Yes.
And a speedy one, I would have thought, not only in the interests of other people, but in the interests of this practitioner.
Yes.
Because it may be, as the policy of the contract says, it ends with this phase. The investigation finds that there's nothing to be recommended even to the case manager.
Yes.
And I think one of the submissions you're making implicitly to this court is that if one over-judicialises this early phase, that won't necessarily be the interest of practitioners.
My Lord, yes.
Here we are. I don't know how long it's been.
We put this in 42.3.1 of our skeleton argument, which is that you are bringing in a regime that will not only delay, it will cause a defensive culture as well. In other words, if a respondent trust or trust is looking at an investigation, if what they know is going to happen to them is there is going to be this firestorm of requests, something like in this case, for the documents that they've got, the documents that they've seen, the documents that they've had and a request for them, then that will create inevitably a defensive culture. It will mean that you won't start these cases unless they're absolutely clear and you're absolutely sure about them. And that's contrary, aside from the issue of delay and cost and bureaucracy, that will only have a negative influence on what this whole process is about, which is ensuring patient safety. That will be an undoubted outcome. But I explain all that in my skeleton argument.
Yes.
I say Very, very simply, rely on the ordinary language. The ordinary language means correspondence. Correspondence means that which emerges from the case, and the examples I've given are respectfully correct. So that's the end of ground one. Ground two, relating to the case, well, it's got to relate to the case. There has to be a causative or a relevant connection with the case, because otherwise it wouldn't exist. In other words, as your Lordship gave the example a little bit earlier, letters that appear back in the March of 2019, which are sought now, could not be and could never be, in my respectful submission, relating to this case. They may inform some of the background, and I was slightly surprised by the skeleton argument put in by my learned friend saying that the Dr. Campbell report was brought about through parental lobbying. I needn't take you to it. The Campbell report was expressly agreed by the claimant in a meeting, 3 meetings in the summer of 2019. It's irrelevant anyway because the TORs don't relate to why Campbell was instructed or why the whole process started. The TORs relate to what happened on the 3rd and 4th of December. But I was surprised to see that reference in there. I can give you the reference to the...
Well, I don't think we'll stop you saying this because we didn't stop Ms. Criddle saying it. But,
no, but
it's not really the heart of the point. The real point is the one you've just made. Why the investigation was started is not relevant to the investigation in the relevant sense.
Yes, to the claimants, to the hospital's concerns about the claimant's conduct. It's irrelevant. But it has to have a relevance test relating to the case. It undoubtedly needs something which arises as a result of the case.
If your respondent's notice point is right, I'm not saying whether I accept it or not, I don't know at the moment. If that point is right, then does any of this arise? Then it's just related, you're saying it's the stakeholders' correspondence related to the case with a capital C.
Yes.
So would any of this then arise?
No, because the witness statements aren't correspondence, and the letters that are sent in the March can't be related to the case.
But suppose that we don't accept your respondent's notice point, that the judge didn't. So then,
yes.
Then why, perhaps you can help me with this. Speaking for myself, I have a little difficulty with the judge's reasoning. Why doesn't related to simply mean related to? Where does she get the test of relevance from?
Well, it related to the case has to have, and she explains this in 99, which I don't think we, in fairness to the judge, we looked at in the sort of focus that we ought to. Where she talks about nexus and causative connection between the correspondence and the investigation.
Yes, but why do we have to start? This is what lawyer. I mean, I don't mean any disrespect to this judge. We all do it. We all substitute other words. Why don't we just say relating to means relating to?
That's what she's saying. Although she's elaborating
no, she's
by
not
saying
with respect. She says there's a test of relevance.
Yes.
Relevance then starts, and this leads on to grounds 3 and 4 of the appeal. Relevance then imports some exercise of judgment. Whereas related to might be, and anyone can see, this letter is from the NCAS, dated the 3rd of March, and it is related to this case. I can see that. But why do you have to exercise some kind of evaluation? Or is the content of that letter relevant to the case? Why are we getting into all of that?
I see the attraction of your Lordship's point, which is that it's a very straightforward exercise, which is the NCAS says this relates to Dr. SB.
And if I may say so, it sits very comfortably with your respondent's notice point.
Yep.
If that's all it means.
Yep.
But if that's not what it means, then speaking for myself only, I do have a little bit of difficulty that some kind of relevance test requiring some kind of judgment to be formed has come in.
Well, respectfully, there would always have to be some form of judgment because it's the case investigator's role to, as it were, comply with 1.16. That's her zone of influence. So she, and as 1.14, 1.18 makes absolutely clear in the procedure, she's got the discretion. It's vested in her how the investigation goes.
No, but if my lord's point is otherwise good, it isn't. This isn't one of. There are lots of discretionary judgments he or she will have to make, but this isn't one of them. My lord's point, this essence of my lord's point is related to is, for all intents and purposes, you can imagine occasional marginal cases, but is essentially objective. You just look at it and it'll be clear, and then you don't have to make any judgment at all.
Yeah. The difficulty with that might be that if you have cases like this, then you get into the conundrum of, well, what do you do about the letter for the purposes of whether they're disclosed or not? Because if the claimant wants to see it, they start an action, then you're obliged by disclosure to give it. We said, no, we're not. But you'll be obliged on the claimant's analysis to give it to the trial judge in order for he or she to determine whether that relates to the case or not. And then that immediately disrupts the very reason why you weren't giving it to them in the first place, is because you're respecting confidentiality principles. So you open up a really difficult area, which we faced in this case, a really difficult area, which is that, well, simply by issuing proceedings, the claimant gets what she wants. We're not going to allow that, because that would then breach others' interests, and therefore we took a in-the-middle principle stand, which is to say, no, you have to prove that you've got the entitlement to this. So if my Lord Justice Singh's point is right, the difficulty might be that in an adjudicative process that we've got here, an adversarial process that we've got here, you might have having to spill over the documents, cough up the documents anyway, which makes a nonsense of your objection in the first place. That's the difficulty that we part of the difficulty that we've had in this case, which is that the claimant can get it just by issuing proceedings. That can't be right. Can't be right. Particularly if we're doing it for an entirely legitimate and lawful reason. So that's what I anticipate practically, my Lord, is a difficulty with...
We may not, I don't want to take up time unnecessarily, but I'm not sure that I would accept that proposition, because that seems, with respect, to be confusing. Even if relevance is the test, that risks confusing relevance with there being some other good reason for not disclosing something which is relevant. That's quite murky territory, but I'm not sure that's what this case is about. This case is about simply the construction of clause 1.16.
I see that. We get on to ground 3.
Yes.
Whose decision is it? Slightly put off my stride in relation to this, because this was not front and centre before the judge. This came in as a half note in the list of issues, and this issue was not pressed other than saying it in principle. So none of the authorities were shown: Skidmore, Matu, Idu, which is my Lord Justice Underhill's most recent judgment on the point, which is basically saying who is the arbiter here.
I'd forgotten that was. I remember Idu. I'd forgotten that was the issue, but
that was the issue, as far as I can remember.
One remembers. Yeah.
So I'm slightly knocked off balance in relation to that as a proposition. But what we say is, for these purposes, the judge got it absolutely right in that is a classic decision of a case investigator. In other words, classic exercise of their discretion. I know this goes back to my Lord Justice Singh's prior point. It's a classic decision in which they make a decision as to whether they make a judgment as to whether something is relevant. And
just to see where this fits into the structure of the overall appeal, is this right? This again only matters if you're wrong about the respondent's notice point.
Yes.
So we're into the territory of the case investigator being entrusted, you say, with having to form some kind of judgment about relevance.
Yes.
So it may be that, certainly on your primary submission, you don't even get to this stage of the case.
But we do have to get there because the judge went there.
Quite. And if we do, then as I understand it, you submit that we're in the territory of Braganza and that it's very much a matter initially for the judgment of the employer.
Yes.
It doesn't mean there's no scope for judicial control, only that it's rationality review.
Yes, you're not looking at the decision outcome, you're looking at the process, which is the rationality exercise.
But you then do get to the difficulty that the judge is not given the material with which to assess the rationality of the decision.
Well, that's the point I just made about the unforeseen or the unpalatable aspects of the argument that this is.
But it's inherent in the route that the judge took. She got round it by, and this may work, but we weren't actually shown, perhaps you were about to show us, Dalglish,
Yes.
by suggesting there's really a two-stage situation, that the claimant has to show a prima facie case of relevance. If they don't, the judge may well, the judge may well decide that, in the absence of reasons why it wasn't relevant, that it was.
Yeah. Yes.
You think that works?
It's a basic threshold argument, which is, and I take you to IBM and Dalglish 368. In fairness to the judge, my lord, she raises this at paragraphs 12, 100 and 105 of her analysis. So it's not just one reference where she gets the reference wrong. She deals
You gets
with
it wrong in both places.
Um,
The only reason that was, I was looking at it last night when I hadn't taken the bundle of authorities home, and I thought, never mind, I'll look it up on the web. It took me ages to find it. She'd misspelt the parties, and she hadn't given a reference.
Well, you know who you can take that up with, my lord. But I thought she did. IBM UK Holdings, at page 70. So paragraph 12C.
Perhaps I didn't read carefully enough. This is not worth spending time on.
No, it isn't.
I will, though.
But you know who to take it up with, otherwise.
I wouldn't dream of taking it up with the judge or our clerk.
So she, as it were, sketches out the issue, so to speak, of how Braganza and IBM arises. So you get a reference to Braganza at 12A. You get a reference to the distinction being drawn between an employer reason and an employer discretionary power. That's at 12C. And then you've got a D.
So, sorry, which page are we on?
Page 70 of the judgment, my lord.
Oh, I see. Sorry. Yes, right, yeah.
We've not looked at this in any real focus. And then she makes further reference, the land judge makes further reference to the Braganza test at D, and then you've got it at paragraph, the reference to prima facie case at paragraph, prima facie is in paragraph 100, and the misspelling of Dalglish at 100 in the final paragraph.
Yes, okay, sorry.
And you've got a further reference to it at 105. And 105 really is where it comes into focus. Although the reference there is not actually correct, because the paragraph I'd like to take you to in IBM, quickly if I may, page 368 of the authorities bundle, which was a case about trust and confidence and pensions and a decision taken by the employer to change pension benefits, whether that breached the implied term. So that's page 368 where it starts. For these purposes and for brevity, the decision of the court is at paragraph 57, page 390. A single paragraph will suffice.
Sorry, where are you taking this to?
390, paragraph 57 of the Court of Appeal's joint decision. In our judgment. Can I just invite the Court to read that briefly, quickly?
Yeah. Yeah.
Yep, and applying those tests, paragraphs 112 to 114, is the dealing of the by the judge of what she made of the point that there was a breach of the rationality test. She rejected it.
The origins of all of this, of course, are public law.
Yes.
Because Wednesbury was sort of imported into private law by Braganza.
Yes.
And unless I'll be corrected if I'm wrong, but even in the public law context, where we do tend to take a relatively relaxed view about evidence and so on, nevertheless, there are some evidential requirements. So you can't, for example, just come along to court and say, I think this decision may have been irrational. I have no evidence to support that proposition whatsoever. But because if I start proceedings, the court will have a look at the underlying material, and because the respondent will have a duty to assist the court once a claim, at least once a claim has got permission. It doesn't work like that. Even in public law, you have to have something that you put in front of a court which warrants, say, the grant of permission, that there may be an irrational decision. At that point, the respondent may well have to file evidence. At that point, I think the analogy with public law starts to break down, which is one of the reasons, speaking for myself only, I've always had some difficulty with Braganza. But there it is. But yeah. What you're saying is that this replicates in a private law context what the courts have long said in public law.
Yes, Braganza incorporated the Wednesbury, or didn't quite incorporate, brought it much closer to the common law assessment, is the better way to describe it. But 57 in IBM couldn't be clearer, which is that your obligation, if you're a claimant, is not just to assert, but you also have to demonstrate some material that will put the respondents on notice and prove that their decision has been taken correctly. And in this case, the claimant loses on both counts. There is no prima facie evidence. That's how the judge deals with it. There's no prima facie evidence that suggests that Miss Wood's decision was improper. And she finds, without seeing the letters, she finds that she acted properly anyway, based on her assessment of her as a witness and no bad faith allegations being made against her. So, very briefly, therefore, I say that if we get into issues 3 and 4, the judge's decision is unimpeachable and is correct. My respondent's notice, well,
you've largely dealt with.
I've dealt with it, I suspect. First point, can I just take the court to briefly to it? It's had
The notice itself, or how it's dealt
the
with?
notice itself, page 60, if I may, in the bundle. Paragraph 3, page 60. Broken into 4 parts. First is the pure killer point, we say, which is it has to be relating to the case. Second one, or the second argument is that what it means. So first is the issue of principle of the case. The second is, well, who does it apply to? We say the stakeholders. In other words, communications that are sent or exchanged pursuant to the NHS process relating thereto. The third issue, or the third part of the respondent's notice, is really run in with the fourth, which is that if the judge is right about the assessment or threshold being only relevance, that can have some serious difficulties for trusts. There has to be something more than relevance for the purposes of the disclosure correspondence relating to the case. All the sensitivities that we identified. One thing Elisabeth hasn't addressed you on is if you're in any way attracted by any of these arguments, where does it all lead to? Where does it get us? Where does it get the claimant in particular? Relief and related matters. That would have to be a matter, I suspect, which will await your judgment.
Well, I'm inclined to think it would, though it would be not insubstantial. I'm not asking for submissions. What would your suppose you lost? Would there be circumstances in which you said injunctive relief was nevertheless not appropriate?
Absolutely, my lord.
Yes.
Depending on what the injunctive relief is as well, because if you look at the loan offence skeleton, which
I think
differs from the remedy sought in the appeal documents, they seek, as it were, a complete block on this process being enduring, which would just be a wholly inappropriate issue. But I don't want to waste Miss Criddle's valuable time.
Well, she's got more time than she may have expected, but I think. No, I don't think we want to hear either you or indeed Ms. Criddle on relief. If it becomes relevant, we will have to find an appropriate process.
Yes. Unless there's anything else in the court, those are my submissions.
So thank you very much, Mr. Gordon. Well, yes, thank you very much, Mr. Gordon. Yes, Ms. Criddle.
Thank you, my
The
lord.
fact that you've got rather more time than at one point in
It's
this,
not
if you
an
might.
invitation to take it all up. I'm very well very well aware of that. So I hope not to trouble the court overly, but there are certain matters which, in the interest of getting on with things, that I left and said that I
Fair
would
enough.
come back
Fair
to.
enough. As long as yep.
So there is a lot has been made of fairness, and fairness in terms of whether the appellant is being fair to the respondent or not, in terms of the process that's been adopted. I know the court will have this well in mind, but the chronology of events is dealt with in the judgment, starting at page 73, and I'm sure the court will have noted the months and months that it took to get disclosure of documents from the respondent. So the respondent wasn't exactly forthcoming.
We stopped pretty effectively, Mr. Gorton, from making points of this kind, and I don't think we should allow you to.
But I am going to come to a rather more important point, which is the precise sequencing. And my lord, at paragraph 42, you will see a reference to an email of the 24th of August in which Ms. Wood, who's the case investigator, says, "These are the documents which the trust have given me permission to share. These are the documents which relate to the investigation." And it may be that I should have taken the court to this earlier, because that, my lord, is the point that shows that the question of data protection consent simply doesn't arise until at a later stage, when the respondent then goes off and speaks to people about consent. And that is an important matter, because the question of data protection is being treated in this case, well, it's the tail that's wagging the dog.
It doesn't sound to me like a reply point. The words data protection did not escape Mr. Gorton's lips.
And then there are the issues then that are raised directly by the respondent's notice. And first of all, it's said by Mr. Gorton that he says two things. He says that the correspondence has to relate to the MHPS case itself, and he says that must be in correspondence about the MHPS investigation with stakeholders and concerned parties. Now, he accepts fairly that was rejected by the judge, and I say rightly on this point. For the court's note, it is page 86 and paragraph page 86 in paragraph 98, where she says that she does not accept the defendant's submission that correspondence in this context is limited to those professional organisations which tend to be involved in an investigation, does not extend to correspondence with relatives. There is no express limitation in the policy to correspondence with professional bodies. Instead, the sentence in question refers to any correspondence. The only expressed limitation is correspondence relating to the case, not as to the source of it, and then refers to the importance of a purposive interpretation. So to deal with Mr. Gorton's points in turn, first of all, the idea that the case has a defined meaning for the purposes of MHPS. Well, as to which I say, no, it doesn't, because sometimes MHPS talks about the case, and sometimes MHPS talks about the investigation of concerns, and that you will see.
I think Mr. Gorton accepted that those terms were used pretty much interchangeably.
Yeah. But it is, my lady, a point that has some significance, because if one looks, and if I may, it's page 202 and paragraph 100. Page 202 and paragraph 1.14, and that deals with the obligations of the case investigator. And the first one is to be responsible for leading the investigation into any allegations or concerns about a practitioner, establishing the facts and reporting the findings. So that's an instance where
Sorry, what was that quote from?
it is page 202, my lord, clause 1.14 of the MHPS policy, and it's the very first obligation of the case investigator. So there, MHPS doesn't talk about the case, it talks about the investigation into any allegations or concerns about a practitioner.
But that clause is headed the case investigator.
Yes, those, my lady, are the obligations.
But the investigation and whatever concerns are the ones which are the subject matter of the investigation,
Yes.
which will be defined in terms of reference. I don't see any inconsistency there.
Well, the point is that MHPS doesn't talk consistently about a case. Sometimes it talks about a case, sometimes it talks about an investigation into allegations or concerns. But what you don't have, I suggest, is case used as some sort of term of art in MHPS as meaning only the MHPS process and nothing else. And I've already taken the court, and therefore I won't take the court again, to the observations of Mr. Justice Andrew Smith in Hussein, in which he says, well, correspondence can relate to the investigation process, the process of dealing with the concerns, but it can also relate to the allegations and concerns that are being investigated. There's no difficulty about that. That indeed is how the clause was interpreted in Hussein itself. There is also, as Mrs. Justice Thornton observed correctly in her judgment, nothing at all in the MHPS policy or MHPS itself which limits the identities of those between whom concerns can pass. You might have correspondence with, to use Mr. Gorton's nomenclature, stakeholders. You might not. It all depends on the case. And as of course, as you observe, my lord, concerns don't necessarily need to be concerns of a clinical nature at all. They might be concerns about somebody's behaviour towards other members of staff, or a concern that they've had their fingers in the till. And in those circumstances, it's very difficult to see meaningfully what clause 1.6 is driving at if all it gives the doctor is the right to see correspondence with stakeholders. And of course, the court already has my point, that there is nothing in MHPS which excludes correspondence from being correspondence with the case investigator. And it is also then suggested by Mr. Gorton in his respondent's notice that it is in some way contrary to public policy or the public interest to allow for a right of disclosure. And he says this, and this is page 60 of the core bundle. First of all, he deals with the case. Second, he talks about who you might have correspondence with. But then he says this at paragraph 5, that the current interpretation of correspondence relating to the case will cause real concerns and practical difficulties. And then it talks about the prospect of highly sensitive and confidential reports being disclosable, and what's said to be whistleblowing, fraud or harassment concerns. And then it goes on to talk about the public policy and the public interest and the Robert Francis review and all sorts of things, none of which was in evidence before the trial judge. But it is genuinely difficult to see, well, in fact impossible to see, how it said that providing documents to professional people to allow them to comment on them as part of providing their view of events is in some way contrary to public policy or the public interest. In a moment, I'll come on to what I'm calling relevance is not enough, which is the fourth point that Mr. Gorton makes. But just before that, I should say this. Mr. Gorton, in his submissions to this court, has, for the first time, accepted that there might be an obligation on an NHS trust to provide disclosure of documents. That has never been the respondent's position. It was not its position at trial. It's not its position by its respondent's notice. It's not its position in the skeleton argument. It has been said consistently. And this is how Mr. Gorton started and changed his position only in response to questions from the court. The respondent's position has always been you do not get disclosure of any kind, save what we choose to give you at the hearing stage.
Well, I must say, I can't say what his submissions were below, but I didn't see his position as being quite so extreme in anything he said to us.
There is a difficulty, however, with this analysis. If you say, well, let's just say that it is an aspect of the implied term. The difficulty you then have is that is using the implied term to get round an express term of the contract. If clause 1.16 provides for a right to
Well, that assumes what you need to prove.
Yes. But
if 1.16, the relevant bit of 1.16, is directed to something completely different, then there's no inconsistency.
But, my lord, I think there may be a difficulty because if 1.16 simply doesn't allow you to see anything at all, no problem. And because then the express terms of the contract are making no provision. But 1.16 is providing for something, even on Mr. Gorton's case. 1.16 is providing an obligation on the trust to hand over correspondence relating to the case to the doctor. The respondent says that means the communications about the MHPS process. So there is a right to disclosure. It's incredibly limited on the respondent's analysis, but nevertheless it is an express term of the contract, and then you're using the implied term to get round that. In my submission, the correct analysis as a matter of law is that you have to grapple with what 1.16 means and say this must provide for a wider scope of disclosure, because otherwise you simply don't get anything. And that is precisely the basis upon which we lost on the implied term below, is that the judge said you cannot use the implied term to get round the limitations of clause 1.16.
This issue arises in many legal contexts and depends on what you mean by get around. Speaking for myself, I think I would prefer to use a phrase like supplement. I mean, it's long been established in the common law, in public law, that the common law will supply the omission of the legislature. That was said in 1863. So the fact that statute, let's say, gives you procedural rights, A, B, and C, doesn't mean that the common law is getting around the statute by supplementing the statute, by adding procedural rights X, Y, and Z. Of course, you have to look at the particular context, and it may be that it's inconsistent with the statutory framework and so on. But as I understood him, all that Mr. Gorton has submitted today is that the terms of clause 1.16 do not require what the appellant submits, it does require. And that's, in a sense, the end of the case then. But he, in the course of argument, he has been prepared to accept, in answer to questions from the court, that's clause 1.16. That doesn't necessarily mean that there might not be, depending on the circumstances, some other source of an obligation to make disclosure. And he didn't take an absolutist position, which, if I may say so, was admirable.
My lord, the difficulty that Mr. Gorton inevitably runs into is that if you say clause 1.16 provides for a certain very limited amount of disclosure, how can you then say at the same time that the implied term gives you a right to a broader range of disclosure at the pre-interview phase? And this is precisely the point, and it's page 90 in paragraph 111 that was made against me on this by Mrs. Justice Thornton, where she says, "I've concluded above that the claimant is not entitled to the documents sought pursuant to the express terms of the contract. This is on the basis that the RCA statements are not correspondence, and the correspondence with the patient's parents is not considered by the case investigator to be relevant to the investigation. To permit the claimant to see the documents nonetheless would be to allow her to use the implied term of trust and confidence to modify the express terms of the contract." This point was acknowledged in passing but not determined in Gregg, and then she cites from Gregg. So that is the difficulty, is if you have some right of disclosure, how do you use the implied term to give you something broader?
But isn't it ultimately a question of correct construction of paragraph 1.16? And the issue is that an exhaustive and exclusive statement of the rights, or is it something else? So can it be supplemented by duty to be fair? I mean, I haven't expressed it very well.
Yes. Of course, my lady, I take that point, but if one looks at the MHPS, which is intended to be a code, a disciplinary framework for doctors and dentists.
Well, a framework and a code are not the same thing.
Forgive me, my lady?
I said a framework and a code are not the same thing.
Forgive me, and then I was speaking too broadly. It is a framework. It is described as a disciplinary framework, and that is how I should.
And it is a framework
describe
of
it.
which, of course, you can point to particular detailed provisions, of which 1.16 is one. But the general message is how the investigation is conducted is absolutely up to the case investigator, widest possible discretion. So I think it certainly isn't a code. It is only a framework.
Well,
And in those circumstances, it's not particularly surprising that no explicit provision is made for matters which are left to be left as matters of fairness. What's a fair process?
Well, I won't labour the point, but the provision as to discretion, the discretion of the case investigator, is something it resides in clause 1.18. But of course, clause 1.16 is a bundle of rights that the doctor has, and it is the only place in which one sees anything approaching a right to disclosure is 1.16. So if one is not looking in 1.16, the court has my pointer as to, well, how do you then look to something else to modify the provision?
One reads into the discretion conferred by 1.18, the discretion about how the investigation is to be carried out fairly. Because, I mean, and that almost emerges from what follows: ascertain the facts in an unbiased manner.
Yes.
So,
well, my lady, so the first point is the one that I've already made about the relationship between express and implied terms. The second point is to leave the question of whether or not you get any disclosure at all as being something that you need to read into a clause which gives broad discretion to the case investigator to decide what to do is a very, very surprising reading of MHPS when one considers what went before. Because it is, and if you take the full ramifications of the respondent's argument, it's completely discretionary. The case investigator can provide, can withhold, the doctor can't do anything about it. Unless the list exists, the doctor doesn't even know there are documents. And of course, if the doctor challenges, then the doctor doesn't get to see the documents anyway, because that is said to be getting the documents by the back door. It is a truly, in my submission, surprising state of affairs. Mr. Gorton then said, gave some examples about counter fraud and whether or not counter fraud investigations might be a reason to withhold documents. At risk of stating the obvious, none of this was in evidence before the trial judge, and therefore to start saying what counter fraud might or might not require, I submit you cannot do on appeal. But I've accepted the point already. There may be conflicting obligations, of course there may be, that may require redactions, for example, of documents, but it doesn't mean that you simply don't provide the documents at all. He also said effectively that it would be dreadful, very, very difficult for trusts if my interpretation is correct. And again, it is genuinely difficult, impossible to see how that is said to be the case. What has generated the litigation challenge here is the respondent withholding documents, saying they're not relevant, refusing to explain why they're not relevant, and holding on to them, and then taking us through this process. It doesn't create pressures, it doesn't create difficulty if you simply have a provision to turn over the documents relating to the case. Then as to relevance, I respectfully agree with the observations of my Lord Lord Justice Singh. It doesn't say relevance. At the most simple point is one does not see the concept of relevance appearing in MHPS at all. And it's once you import considerations of relevance that you end up with the sorts of issues that you get in this case. This is the sort of thing that generates litigation, and not the interpretation that the appellant puts on matters. But what additionally on this point, Mr. Gorton was asked whether relevance still comes into play if the argument in his respondent's notice is accepted. Well, of course, it must do, because if one looks at page 61, forgive me, and paragraph 6, he says you need relevance, but you need more as well. So he is still saying, even on his respondent's notice, that you consider whether or not the document is relevant. But he says relevance is not enough. You must have some generalised discretion on the part of a trust to withhold documents even if they're not relevant. As to which I say two things. First of all, it wasn't the respondent's position below. The respondent expressly accepted below that its position was one of relevance, and one sees that in the judgment, and for the court's note, it's page 82 and paragraph 85, where Mrs. Justice Thornton is recording Mr. Gorton's submissions, and where he says correspondence means written communications, e.g. letters or similar. It does not oblige the defendant to give disclosure generally of documents, or in particular documents that the case investigator may have seen during the course of the investigation. Correspondence relating to the case means such communication between the defendant and other related and concerned bodies in relation to an MHPS investigation, including the PPA and GMC. And then over the page at page 83, no obligation to provide correspondence unless specifically identified, no obligation to provide before it's called for. Relating to the case is a test of relevance and is prima facie a decision for the case investigator. So it wasn't said relevance plus, it was put fairly on the basis of relevance. I think it was my Lord Justice Singh who described it as a murky territory to start having documents which are relevant but which can nevertheless be withheld, apparently at the discretion of the respondent. And the simple point is this: there is nothing in MHPS at all which provides for what I'm calling the basket of rights in paragraph 1.16 to be overridden by the respondent. It amounts to saying that the trust can withhold relevant correspondence from the doctor, even though the outcome of the investigation may be a disciplinary hearing, at which termination of employment may be in contemplation. The doctor never gets the document at a later stage and cannot challenge that decision by the trust, either because they never find out that the document exists, but even if they do, they can't meaningfully challenge the exercise of discretion. And even more so, one would expect the clearest of language in MHPS to say that trusts are entitled to have this sweeping discretion, and in my submission it is simply not there. I know that the court doesn't want to hear about relief at this stage, so unless there's anything else with which I can assist the court, those are the submissions I wanted to make.
My Lord, can I just clarify one point, lest I be accused of saying something different down below to what I'm saying here? I was never asked by Mrs. Justice Thornton to go through the extreme examples that your Lordship gave to me, or the court gave to me, in relation to what happens if there is a killer exculpatory piece of evidence. How does that fit with 1.6 next to the implied term? It was never canvassed down below. And I've only answered it in a fair and balanced way, I hope, for your purposes. So,
okay. Thank you.
It's important that that's recorded. Thank you, my Lord.
Very well, we will be reserving our decision. It's clear that this is a case we ought to decide as soon as possible, and we will try to do that. We will follow the usual procedure of circulating a judgment, draft judgments in advance for the parties to try to agree consequential orders, and that will, if it becomes relevant, that will be the opportunity to make submissions about relief. Whether we will require an oral hearing to deal with such submissions really depends on what they are, but let's cross that bridge when we come to it. Subject to that, any consequential matters will be dealt with in writing, and obviously please take the opportunity to draw our attention to any typographical or other minor errors in the draft judgment. Thank you both for your very helpful and, albeit with some encouragement from the court, focused submissions.